Welcome to Family Court Conversation with Everyman Justice. I'm Friend, a McKenzie Friend and the host of this podcast. Today I'm joined by Simon Walland. Simon has many years of experience in the family court world, supporting parents and litigants in persons, and also training and mentoring McKenzie Friends. In this episode, we are going to talk about how parents can choose support safely, what makes a good McKenzie Friend, what red flags people should look out for, and what standards really matter in this unregulated sector. We will also discuss training, newcomers to the professions, reviews, networks, AI, and where McKenzie Friends work may be heading in the future. Before we begin, this conversation is not legal advice. It is discussion based on our own views, experience, and opinion. Anyone involved in the family court proceedings should consider their own circumstance carefully and seek appropriate professional advice when needed. Simon, thank you very much for joining me.
Thank you for having me.
I would like to start the beginning because many parents first come into the family court system for a place of a fear, confusion, and panic, not from a legal knowledge. Your own route into this world started from personal experience as a father in the family court system. Looking back now, what did that experience teach you about how frightening and lonely court can feel for parents?
I think looking back on it, and it was 25 years ago now, but looking back on it, it was very frightening because of the unknown. You've no idea what's going to happen, and going to court on your own, you've got nobody to talk to, nobody's interested in you at all. And I can remember my ex had a solicitor who kept coming over and having a go at me. Well, I felt he was having a go at me. And that was just pushing me even deeper into the fear of what was going to happen. And when I went into court, I didn't know what I could ask for. I didn't know what was going to happen. And not knowing that there were things that I could have done at that hearing that I wasn't aware of, that I find other people, clients of mine will come to me and say, I've had my first hearing, this happened. And I'll think, well, why didn't you ask for this? And why didn't you do that? Because you could have got it. And you've actually got nothing out of this. And that's the issue really for going to court with no knowledge at all. It's not difficult to get some knowledge, even basic knowledge.
Mm-hmm. Do you still see parents who feel the same way? They know they want to see their children, but they are not sure how to explain that clearly to the court?
Yeah, I would say I always see that. And it's not only with children, it's also with finance and domestic abuse cases. The people don't, and it's reasonable to see this, that they've never been to court before. They don't know what's going to happen. And if you can put forward a sensible proposal, you have far more chance of getting it. I very often see people who are unreasonable and expect too much, and you lose credibility when you go into court if you're not reasonable. And you should always look at, again, very, very difficult for somebody who doesn't know. But if you can understand what a court would be happy to give you and you ask for that, then you're going to get somewhere. If you ask for 10 times more than that, you might get nothing. So it is very difficult. So it's very difficult when you don't understand the process to know what to ask for.
I absolutely agree. Most of the people, when they get into the family court system, they don't understand because it's not that professional. When did your own experience become the reason you wanted to help to other parents through the family court system?
Well, when I first went to court, there weren't many McKenzie Friends about at all. And I had my hearing, and then somebody else said to me, oh, I've got a hearing next week, could you come with me? And I thought, well, how do you do that? I don't see how I can come into your hearing. And he said, well, there's this thing called a McKenzie Friend. And I said, well, okay, that's fine. I'll come with you. And I went with him, wrote down everything that happened. And I couldn't really see the point really of what I was doing, but I was there and we were chatting, and, you know, I supported him in that way. But it really turned into something much bigger, because having been to court with him, other people would say, oh, you've been to court before, could you come with me? So I then started to do it a bit more regularly. And then I had a hearing in Romford, actually. And the guy that I was helping got very frustrated. His ex-wife was laughing at him. The social worker was trying not to laugh. And he just stood up and threw his papers at the judge and told the judge to F off and walked out. And I looked at this empty chair next to me and I thought, I wish I knew more about how to help people than to be in this situation where I've not been able to help him. And the judge said, oh, could you go out and have a word with Mr. Smith? So I went out and had a word with him. And he was just so angry and upset about the whole thing. He said, you know, forget it, I'm going to move abroad, and that's the end of it. But that then led on to me looking into doing some legal qualifications.
It's a great story how you become a McKenzie Friend. Before we talk about good and bad McKenzie Friends, I think we should make the basics clear for anyone listening who may not understand the role. Can you explain the basics clearly for listeners? What can a McKenzie Friend do and what can they not do?
Well, the basis of a McKenzie Friend is that you can go into court with somebody and you can support them. And that was really where it originated. So therefore, anybody could be a McKenzie Friend. And I always say to people, if you want to, you could take your next door neighbour. They won't have a clue what to do. They can support you socially in the hearing, but they're not going to be able to help you legally. Now, the role of a McKenzie Friend has developed into people seeing that their legal experience and their legal knowledge can help other people. So that has grown and grown, but sometimes it can go a bit too far. Now, the courts wrote, I think it was 2010 was the first time it came out. There was a guidance for McKenzie Friends, what you can do and what you can't do. And I boil it down to basically, you cannot write letters on behalf of somebody else, and you cannot speak in the hearing to the judge. Now, on the issue of letters, I will always write a suggested letter or an email. I always write statements for people because they don't know how to do it. But I would write an email and say, this is what the sort of thing you should be responding to their solicitor with. You know, they've received a letter from the solicitor. They need a reply. I've written what I think they should send. They will check it, maybe change it if they need to, and send it. I can't send that email for them to the solicitor because that's litigation. So I can't do that. I can't sign papers for them. I can't sign application forms for them. I don't even post application forms for them. I get them to do that. The largest thing and the biggest obstacle really is the speaking in court. Now, you're not allowed to address the judge. I have done it many times, but then I've got a lot of experience, and judges know me, and judges do get to know you after a time. But then that creates a bit of an issue in that if things don't go well, the client is going to be unhappy with you. But then your client isn't, and I see this so often, they're not able to express what they want to say clearly and properly for a judge. And it's the speaking in court which is the biggest obstacle for litigants in person. A McKenzie Friend can certainly help, but it's not the same as having a solicitor or a barrister there helping you.
I think this is important because parents often hear words like solicitor, barristers, paralegals, and McKenzie Friends, but they may not know what each one actually does. So how would you explain the difference in plain English?
Okay, Solicitor is somebody who will have a legal qualifications. They have the right to be able to speak in court. They can do everything that's required. They cost lots of money, and they can be good or bad. I generally find that solicitors will ramp up the tension quite a lot and come across quite bullying. Even when they're a resolution solicitor, I don't think that makes a scrap of difference to anything. I don't particularly get on with solicitors. I find them quite bullying, I think is the best word. Mm-hmm. They will prepare cases for people. So you would go to the solicitor, they will help you do your statements, prepare your documents, make your applications. Traditionally, they didn't represent you in court, but that has now blurred quite a lot, and they can represent you in court and often do. A barrister is completely different to a solicitor. They don't prepare your case, they don't deal with your paperwork, but they represent you in court. They will stand up and argue your case. That's their skill, that's the job that they do. They are very good at it. It is a skill. It is a difficult job to do. You've got to learn your client's case inside out, and then you've got to present it. And you've got to know every answer to everything that's going to come up in the hearing. They can be expensive, but you now have direct access barristers who can help you in a final hearing, which is where I would recommend using them. Paralegal is generally somebody who is studying law. In fact, anyone who calls himself a lawyer, and I know I call myself a lawyer, is somebody who is studying law or working in law. I tend not to call myself a barrister because barristers are not allowed to advertise, and I don't want to have that problem. I am a qualified barrister. I'm not a practicing barrister, though, so I work as a McKenzie Friend. Informal support from a friend or family, there is always a difficulty with family in that they are often very invested in your case. And I can remember years ago when I went to court, my ex took her dad to court. He was very argumentative. He was an argumentative person anyway. But he was arguing with the judge because he was angry about the family situation. And I thought at the time, if I'd taken my mum, she would have been angry. She'd have been even more angry than he was about the situation. And that's not actually helping in court. What you need when you go to court is a solution to where you are, something that's going to move you forward, not getting angry, not getting upset. And emotions, which everybody has, it tends to be the biggest thing in your mind when you are a litigant in person, but they do not help you in court. You've got to try and be calm and thoughtful about what you're doing. So I think that's really the difference between the people.
Yeah, these are really useful informations. Once people understand what a McKenzie Friend can and cannot do, the next question is how they choose one safely. In your view, what makes a genuine good McKenzie Friend?
I think it's somebody that cares. That's got to be the main part of this. If I have a client and they're going to court, I really care about what happens. I want to win that case because I care. I believe in them and I believe in what they're doing. Admittedly, I've only got one side of the story, but I believe that side. Generally, I believe that side. And my sole focus there is helping them to get what they want to achieve. If I find that my client is being dishonest with me, that bothers me a lot. When things unravel in court sometimes, and it's obvious that they've been dishonest with me, that bothers me as well. But I think a genuinely good McKenzie Friend isn't there for the money. They're there to help people. And that's the thing that I find very, very gratifying about something. And I had an experience last week in court. The father hadn't seen his daughter for quite some time. I made a suggestion in the hearing, and we're actually in a financial case. I made a suggestion about his daughter, and he saw her yesterday. So the first time in a long time. Now, that meant more to me than anything else in being a McKenzie friend. It's that achieving something that is important to people. Because I know from my own experience, when you can't see your children, it's dreadful. It's a horrible experience.
This next point is important because parents are often frightened and may naturally want reassurance. But reassurance is not always the same as good advice. Should a good McKenzie friend tell a parent what they want to hear or what they need to hear?
You can't tell somebody what they want to hear because that isn't going to do them any good. You've got to look at a situation, and I have lots of people that say, well, I'm in this situation, what's likely to happen? Now, I don't know what's going to happen. I'm only looking at one side of the story. But I would be able to say to them that in an ideal world, you should be okay heading towards X, Y, and Z. Nobody can guarantee that. I can't say you will get there because I don't know what's going to come out of the woodwork when we get to court and what the other side are going to say. But on the basis of what you're saying, this is a reasonable expectation that you can get to. Possibly you'll get a bit further. Maybe you won't quite get there. But if you want me to tell you that the children will come and live with you and everything will be hunky-dory, I would say, well, I can't say that. Nobody can say that. It's impossible to know the outcome when you go to court, and it is always a gamble. It depends on so many things. It even depends on the judge at the time. You could have different judges in the same court that will give different answers, and different levels of judge as well. If you're in front of a magistrate, your chances of progressing quickly are diminished by magistrates. A district judge will go quicker, a circuit judge will go even quicker than that. So it depends on so many factors, really. So you can't say what somebody wants to hear. It doesn't do them any good at all.
Let's bring us to a more difficult side of this discussion. Parents often vulnerable when they are choosing help. So I think it is important to talk honestly about warning signs. What are the biggest red flags parents should look out for before choosing a McKenzie friend?
Well, I thought about this, and I think this is a difficult question. If somebody came to me and said, I'm making an application and this is a really straightforward case, I'd look at it and say, okay, this isn't difficult. This is obvious to me where the answer should go. I could do that, but probably the majority of McKenzie friends could do that. Even beginner McKenzie friends could do that, because the case, your situation that you have is very likely to dictate the answer. Now, if you lived next door to each other, the children go to school, which is just down the road, there are no concerns, no issues raised, you're very likely to get 50-50 care. And I'm only talking generally with this. If you're living a bigger distance away, there are issues, there are allegations, it's not going to be as easy to get there, so you need a better McKenzie friend. But how do you know who has that experience other than asking them? And people aren't always honest. I don't know. I think if they are guaranteeing an outcome, that's a red flag, because you cannot do that at all. If they're asking for a lot of money, that would be a red flag to me. If they're asking for a lot of money up front, that would be a red flag. I do find it a difficult question to answer, because you're going into something that you don't necessarily understand or know what to look for.
Mm-hmm. One of the things I see online is very confident language, people promising result, promising contact, or making the parent feel they will definitely win the case. How dangerous is that promising false confidence? Well,
it is very dangerous, because you just don't know the you don't know two sides of the story. I have, in fact, as a very simple example, I was in a hearing with a guy that I was helping. He had to ring his children at 6:00. He phoned at 6:00 and the phone wasn't answered. So at the time, I had rights of audience. I was speaking for him in court and I was questioning his ex about it. And I said, but he did ring at 6:00, didn't he? And she said, yes, but he rang at 5:00, 5:05, 5:10, 5:15. He'd rung every 5 minutes and she stopped answering the call by then. So there was a reason for it, but I didn't know that until I was in the hearing. And he looked completely wrong and bullying and harassing and everything else in that hearing. I was unaware of that. So you just do not know what's going to happen in court. And therefore you can't say that something is definitely going to happen. You could say it's likely to happen, but we need to see where things are going to go. But you certainly can't confidently say to somebody when you know nothing at all. And Facebook is the worst thing that I've found, that people give a very small part of the story and then expect an answer. And that just doesn't work at all.
I understood. What do you think? What should a parent agree clearly with the McKenzie Friend at the start? For example, the role, the scope of the work, fees, communications.
I think you need to set out how things work. The work that we're going to do, the terms and everything else. I normally just put it in an email now and send it to people. But previously I had a properly prepared document with terms and conditions in it. And I think that is the best way to go.
Mm. If a McKenzie Friends believe they can no longer support a client ethically or professionally, what is the right way to withdraw without leaving the person exposed in mid-case?
This again is a bit of a tricky one, because you start off with a client and you believe in them, you believe their story. Ethically and professionally, you need to pull away from them, but it's difficult because you're partway through, unless you can move them to somebody else who's probably going to have exactly the same ethical and professional issue with them. So you don't want the other person to put up with what you've been struggling to put up with. I think it's very difficult. And I had a client recently who became a complete nightmare. They just did not provide anything that they needed to provide, got in a mess. And in the end, I said, look, you need a solicitor to take this off your hands. I'm trying to get information from you. You're not giving it to me. I can give you sample documents to send back to the solicitor on the other side. You're not even sending them. You're getting deeper into a hole. You really need somebody who's going to take over from you, and a solicitor can take over from them. They're probably going to have the same issue with the solicitor, but it's difficult to, you don't want to dump them, because they're going to get in an even bigger mess if they've been dumped.
So you already tell me your opinion about the Facebook groups. The other thing I like to understand, a lot of people rely on reviews, recommendations, and star ratings. Those things can be useful, but I think we need to be clear about their limits. So review can help parents choose support, but what do they actually prove, or what do they not prove?
I have always avoided testimonials. At the moment, I don't have a single testimonial on my website. The majority of my work has come from word of mouth. Now that I've moved into events and training and online mentoring, I need to rebuild an audience from that. And I've been criticized quite heavily from a girl who's helping with marketing, that I need testimonials. So I'm now going to try and get some. But I've always looked at them and thought, how do I know that's true? If somebody says, oh, Simon was the best thing since sliced bread, and then put a name on it, who's ever going to check that, and who knows if it's true? And I've always been very wary of it. And I think you've got to say, well, okay, the testimonial is there. It may or may not be true. Maybe I'm just very cynical about things. I don't know.
Mm-hmm. There are also many words used in this sector that may sound reassuring for parent listening. What is the difference between network or directory or a regulator?
When I can't remember when it was, it would have been at least 10, 11 years ago. There was some research done by the court into McKenzie Friends about whether there should be regulation, how they were working, and those kinds of things. And the main story that came out of that, I think it was Bristol University did it, I can't remember now, but the main story that came out of that is that there should be some regulation and there should be groups, accredited groups. And at the time, there were 5 different organizations that were set up as groups. And not one of them asked me to join, but then I didn't ask to join any of them either. So, but I would wonder and I would question, what is their criteria for letting somebody in? I look at other McKenzie Friends and I question what they say about themselves. I can remember a guy started my training course years ago, and he had a website, and I looked on his website and it said the country's leading McKenzie Friend. And I thought, well, you haven't even started yet, but you can say that on the internet. Nobody knows. Nobody can necessarily check that. He hadn't spelt McKenzie Friend correctly, which was a big clue. And I do see that sometimes. But I think all of these things, if you know the criteria that they will let somebody in, then you can have some reassurance that they know what they're doing. Otherwise, you can only go by their experience and their knowledge.
I think this is where parents may get confused because being listed somewhere or can look very official, even if it's not the same as being regulated. So if parents see words like insured, trained, accredited, listed, or part of a network, what should they actually ask next?
I think this falls into that same thing. They're trained, but who are they trained by? Accredited by who? I think they're important things to know. But the main thing is that if you are looking for McKenzie Friend and you have a particular kind of hearing, now if you were doing a fact-finding hearing with false allegation against you, you need a very good McKenzie Friend. You need somebody with the experience of writing your cross-examination for you, dealing with that area of law. But if you only need a position statement or you only need to make an application, you don't need that level of knowledge. So I suppose it is, again, it's another one of those difficult questions. If you know your case is going to lead all the way down to a difficult final hearing, then you need somebody who is experienced and knowledgeable. Whether being a part of a group proves that, I don't think it does. I think you've got to look at their experience and their knowledge. And I think the length of time, as well as being a McKenzie Friend, the more hearings you do, the more you learn. And I learn, even now I learn things. I was asked something a couple of days ago about an SGO, a special guardianship order. I've never dealt with them before. I've always avoided public law and only ever dealt with parents. So I looked into it and I realised that what she needed was actually very simple. So I've helped her. But that was something that I learned after 25 years. You're always learning with this.
Yes, that's true. You have trained McKenzie Friends for many years, so I want to look at this from other side now. Not just what parents should look for, but what newcomers need to understand before they start helping clients. Many McKenzie Friends start after going through their own family court case. What is valuable about lived experience, and where is the danger if someone thinks one person case is enough to start charging clients?
You can't go by what happened in your own case, because every case is different. Well, every case is different, although they tend to follow a formula, but every case is different. And you need the experience of a variety of cases, but where you can't get that unless you're dealing with a variety of cases. And if you only have your one case, where can you go to find out more and expand your knowledge? Now, one of the things that I have found is that, and it's a very contentious issue, and I really don't want to look at, he said and she said, but domestic abuse cases, I very often get people who work in a domestic abuse charity who want to train as McKenzie Friends. And I try and point out that not all allegations are true. You're helping generally women through one of these domestic abuse charities. But there is another side to it. And there are thousands of cases with false allegations, and you can't just base it on the experience you've had. You need to look at everything from the other side. And that is one of the key skills for a lawyer or a McKenzie Friend, is you look at your case and you look at how you're going to argue your case, but then you need to look at what will the other side argue back. What if what I've got isn't correct and the other side are correct? How is that going to work? And then how can I prepare to argue against what they're going to say before they've said it or when they've said it? And I think you need experience, and you can only get experience as a McKenzie Friend by being a McKenzie Friend. And maybe you've got to limit yourself, certainly limit your expectations, and do the easier cases and build up, rather than say, well, here I am, I'm a McKenzie Friend, I've done my case, I can do anything now, because you can't.
You mentioned that your new hybrid course will build on the original course content, but move more into mentoring, live discussions, worked examples, and mock hearings. Why do you think that type of learning matters?
Well, I started I started training in 2013, and then with COVID, I moved everything online. That I felt made things easier. And I then put together a training course, a masterclass in being a McKenzie Friend. And I put into that course everything that I knew that I could reasonably put into a course. So if you were looking at a children case, everything I know about children cases is in that module. But then recently I've been thinking about this, and I did an event for dealing with false allegations. And as I went through that, I thought, well, when you start off and you've been served a court order, you need to communicate. You communicate with the court, communicate with the solicitor, and communicate with your ex, as long as the order says that you're not allowed to. But how can you do that communication? And I thought, well, that's an element in itself. That's something that I've learned over the years. Sometimes if you get a letter from a solicitor, they can be quite frightening and intimidating. You must do this, we're going to get costs against you. You learn that actually costs don't really come up in family law. I've never had a client of mine who's had to pay costs. And you shouldn't. It should never come up. But solicitors threaten it all the time. So how do you communicate with them, and how can you communicate with the court, which is a bit of a nightmare, and certainly communicating with your ex? And I one thing I found with my ex, if I asked for the opposite of what I wanted, I'd actually get what I did want. But that was just dealing with her. But that is something you pick up over the years. And what I'm now doing with the training, the training is still there. You've still got these training modules. But every month I will be doing a dial-in live discussion about a topic, and we'll talk about the topic. Then I will give people some exercises to do. Maybe how would you argue this particular point in the position statement? What would you do if your client's just been arrested? You're coming up to court. What are you going to do? I always think you need to put these things out there, because if you can describe it, it's far better than your ex describing it, because they're going to describe it in a really bad way. So doing those exercises and then meeting again online, discussing the different kinds of answers that people have had, talking about why it may be good, why it may be bad, that I think is going to give a much rounder depth of knowledge to all the things that I do know from experience that other McKenzie friends maybe don't know. So that's where this hybrid thing is coming in. I would look at maintenance pending suit when you go to a financial case. A lot of people don't know what you need to do to apply for that. You need a statement. There are maybe 5 things you must talk about in that statement. So what are those 5 things? How are you going to do it? What arguments are you going to make in order to get that? So it's all these little things that aren't necessarily covered in traditional training. Negotiating, that kind of thing, cross-examination, lots of things that normally you wouldn't find being covered.
So for people listening who may be thinking about becoming a McKenzie friend, is this still a realistic path, or is the sector becoming too overcrowded, too competitive, or too risky without proper preparation?
I know that over the years there have been more and more McKenzie friends, and I certainly bump into them in court. People that I've never heard of or don't know. Whether it is too crowded, I think in any business, even if it's a garage or I say a supermarket, I think anything at all, there is room for good people who can do the job well. The people who can't do the job well are likely to fall away. And if it is something that you're interested in doing and you feel that you would be good at, then you should certainly try it. And I've always, I've done various things in my life. I've been in the army. I'm an architect. I'm a barrister and a McKenzie friend. But I think if you want to do something, then you should aim high, go for it, and see how it works and see what happens.
Looking more broadly the sector, do you think McKenzie Friend need more regulation maybe, or better voluntary standards, better training, or just simply a better public education about what's the role is it?
Well, I find this quite interesting that if you Google about McKenzie Friends, you will get warnings from the Solicitors Regulation Authority about unregulated McKenzie Friends. And there is always an example in there of David Bright, who was, in fact, he wasn't even stopped from being a McKenzie Friend, but funnily enough, I got caught up in a hearing that his new partner was involved in. And that is an example of a terrible, bad McKenzie Friend. He was ripping people off financially. But alongside that, and the Solicitors Regulatory Authority will have him there saying, this is terrible, McKenzie Friends need to be regulated. Alongside that, you're going to have 5 or 6 solicitors who've been struck off for embezzling funds, fraudulently taking money from clients, getting struck off every day. Barristers are getting struck off every day as well. But coming back to the question, regulation, I think there should be some regulation. I think it's a difficult thing to do because the principle of being a McKenzie Friend is you're there to support somebody, just helping them. You're not there necessarily to be giving legal advice. I think that has crept into it. But I do think there should be some regulation and standards. If you knew you were going to get a level 1 McKenzie Friend or a level 5 McKenzie Friend, you'd know what the difference was. You'd know that they have maybe qualified for that. They have been able to establish enough experience to achieve that. But that would need an organisation to govern them. And I have always felt that there should be some kind of standard so that people know what they get in and know what they can expect from somebody.
I believe the sector is really divided on this regulation, but that should be a minimum that we have. Yes, I agree with this absolutely. With AI and online training, podcast or YouTube and digital resources becoming more important, how do you think parents and McKenzie Friends will prepare for family court over the next 5 to 10 years?
Well, I think that AI is fantastic. I think it is a tool, though. I can remember when sat-navs came out and there were stories in the newspapers of lorries driving off the edges of cliffs because the road was wrong. And I thought, I didn't believe that at the time, but it's there to help you to achieve something. And if you are going to court, if you're going to go through a children case and you go onto Chat GPT and say, I'm going to court, what's going to happen? It will tell you the process. It will tell you every step that's going to happen. That is information that you should have and you could do with, but it isn't going to tell you specifically how to deal with each of those things. And I saw a post that a McKenzie Friend had made a while ago where he said people don't even bother getting a McKenzie Friend to help with position statements anymore because they use AI. And I thought, well, when I do a position statement, I would look at the situation that's happening. Every child is different. If a child needs something or CAFCAS has said something, then, and certainly if CAFCAS have done a report and you're doing a position statement about it, I would quote that report and I would say that, little Jimmy needs football practice on a Wednesday. AI doesn't know all of that. So therefore, you're not going to get a personal position statement. It may be general, it may be good enough for you, but it isn't going to be personal and it isn't going to tell the judge what you need the judge to know about your specific case. And I had an article that I read a while ago about a head of a university psychology department. And he had written a thesis, I think it was a thesis or a document on, can you make yourself happy by thinking yourself happy? And he wrote this thesis, it was marked, and he got something like 95%. It took him 3 weeks to write it. AI did exactly the same thing. It took 1.5 minutes to write it, but they got 50%. Now that to me is the difference between AI and doing something yourself. It will take you a lot longer, but it will be more personal, more correct. AI, I think, is the average of information that's out there, but sometimes it's good information. And I have used it. I think it is very, very good, but it is a tool. It doesn't replace the personal touch which you need. And when you are going to court, whatever CAFCAS say, whatever your ex says, whatever their solicitor says, you are aiming your argument at one person, which is the judge. And you want the judge to listen to what you've got to say and think, you're right, I agree with you, this is what should be happening. And everything you do has to aim at that point. If you need AI as a tool to get you there, that's absolutely fine. but don't lose the focus on what you're trying to achieve. The whole thing is just about the judge agreeing with you and being personal, talking about your children, if that's necessary, talking about points in the Kafkas report, if that's necessary. They all help the judge to look at the whole picture and think, I tell you what, you've got this right. I do agree with you. You should have more contacts. You should have whatever it is that you're looking for, because what you're saying makes sense. And family law is hugely about common sense. And if something doesn't add up, it's probably not true.
You catch the human side of this, and I absolutely agree. And the AI, we need to understand it's a great tool for parents to use, and it's a great tool for McKenzie Friends to use, or even for solicitors or anyone who is working in the family court sector. But you need to understand the limits of the AI. Your own role seems to have developed over time. Are you still mainly doing active McKenzie Friend caseworks, or has your work moved more toward training, mentoring, and helping others raise their standards?
I still do everything that a McKenzie Friend would do, but I try and get people to do as much of their own case as they can do themselves. I think, if you can fill your application form in, that doesn't cost you anything to do. I'm quite happy to check it because it will only take me 5 minutes to check. If it needs something, I can tell you what to change, discuss that, but then you can go and change it. Doing that doesn't cost you anything. Having a McKenzie Friend, a lot of people want that comfort from having somebody who is following their case, helping their case, and understanding their case. So some people who come to me need that, and yes, I do provide that. I also still attend court. I have a training course, or actually it's a coaching course for dealing with a final hearing on finances, and I cover, I don't know, there's probably 20 lessons in this coaching course. I had somebody last week who had a final hearing, and when it got there, he'd done his cross-examination. I reworded some of it to make it stronger. He'd done his closing submission. He'd learned everything up to that point. And I said to him, look, I can attend your hearing. It was an online hearing. And he said originally he wanted me to join. And I said, I can join your hearing, but I can't see what you've got to gain from that. Everything is written down. And he said, well, to be honest, I feel very, very confident now because I understand what the judge is looking for and I understand everything that I need to do. Now, that is a perfect answer, a perfect solution for him. Now, I enjoy training, mentoring and helping others. And, whether I'm helping others directly with their case or helping others to prepare their own case, that's what I enjoy doing. So I suppose I'm moving a little away from working directly as a McKenzie Friend, but I'm now more into training and passing on the education that I have to help other people do their work better.
Okay, let's have my final question. For parents listening who may be frightened, under pressure, and trying to choose support, what is the one thing you would want them to remember from this conversation?
I think you need to look at your case. What are you trying to achieve? And how are you going to get there? What steps do you need to go through to get to that end case? And barristers use this thing called a case theory, where I was just saying a few moments ago about looking at what the judge is going to agree with you. Going to court and anything to do with law isn't necessarily about right and wrong. It's the judge agreeing that you are right. So when you are looking for contacts, or you're separating your finances, or dealing with false allegations, how can you get the judge to agree with you? What have you got to do? You can't just say it's not true. You can't just say, well, I want to see my children more. You've got to show it. And how are you going to show it? Now, if you can find a McKenzie Friend who is going to engage in that and help you to find the points that the court will be looking for, because judges always look for particular points. And in fact, just on that, slightly separately, but on that point, in each of my coaching courses, I do a short video about, in this particular case, what is the judge looking for? What are you looking for? And then what is your ex looking for? So there are three different things. Your ex is trying to stop you from getting what you want. You're trying to get it. But what does the judge want? And going to court is all about giving the judge the answers that they need to make a decision and make the right decision for the child or for finances or whatever. And that's really the basis of the whole thing in going to court. What does the judge want, and how can I get that for them? And that's really what you need. If you need a McKenzie Friend to help you do that, get a McKenzie Friend. If you need a solicitor, if you can do it on your own with some research and reading up about it, that's what you need to achieve. There's your main thing to aim for in any legal case.
Simon, thank you. I think that is very important point to finish on.
Hey, thanks so much.
One of the things that comes through very clearly from this conversation is that choosing a McKenzie Friend is not just about finding someone confident, affordable, or available. Parents need to understand the role, the limits of the role, the importance of the preparation, and the difference between real safeguards and things that only look reassuring from the outside. We have also talked about the responsibility on McKenzie Friends themselves, knowing their boundaries, being honest with clients, keeping the focus on the child, and not stepping into work they are not properly prepared for. Thank you again for sharing your experience, your views on training, and your thoughts on where the sector may be going. For anyone listening, I will include Simon details and relevant links in the episode description. This has been Family Court Conversation with Everyman Justice. I'm Gergely Fried. Thank you for listening, and I will see you in the next episode.